Good morning, Committee Secretary. Can I check whether we have a quorum?
Hi, good morning, Chairperson and everyone on the platform. Chair, we're correct. Shall I do a roll call, Chair?
Please.
Mr. Malamatia?
Good morning, Chair. Good morning, everybody. Compliment of the new season are present.
Good morning.
Dr. Ntwane?
Good morning, Chair. Good morning, colleagues. Compliments of the season to you all. I'm present.
Good morning.
Mr. Mbiani?
Good morning, Chairperson. Good morning, colleagues. I'm present. Thank you very much.
Good morning.
Ms. Muatse? Mr. Muatse was on the platform, Chair. Mr. Monakedi?
Recording in progress.
Good morning, Chair. Good morning, colleagues. I am present.
Good morning. And I heard Honorable Moatse also. Good morning, Honorable Moatse.
Mr. Bergman?
Good morning, everyone. Good morning, Chair, and Happy New Year to everyone.
Good morning. Happy New Year to you too.
Mr. Thring?
Good morning, Chair. Good morning, colleagues, and blessings to you all in this new year.
Thank you very much.
Mr. McPherson?
I'm here. Thank you. Good morning.
Good morning.
Mr. Mulder?
Good morning, Chair. Good morning, all. All of the best for the rest of the term.
Good morning.
Ms. Honiana?
Good morning, Chair. Good morning, colleagues.
Good morning.
Chair, that all members are present, Chair.
Yeah, I think we have a full house.
Full house.
Good morning to everyone on the platform and honorable members. And as other members have mentioned today, we hope that the rest of our sixth term will be a fruitful one as we complete our term of office. Can we have the agenda, please, Committee Secretary? Okay. Are there any apologies?
Chair, we have apologies from the Deputy Minister Majola and the DG, Ms. Mabiji Thompson, as well as the Minister who were attending the Lepotla Chair.
Okay.
So they will
Thank
not be able
you
to.
very much. Those apologies are noted. Then can we adopt the agenda? Can I have a move and a second for the adoption of the agenda as tabled in front of us? Members?
Mr.
Okay.
Monakedi, Chair.
Monakedi.
Thank you, Chair. I move for the adoption of the agenda, Chair.
Thank you. Honorable Mbiani.
Thank you very much, Chairperson. I second the proposal for the move of the agenda.
Thank you very much. So the purpose of the meeting is to receive a briefing from the WTO agreement, on the WTO agreement on fishing subsidies, the Constitution in relation to international agreements refers to the following. Clause 231(1) states that the negotiating and signing of all international agreement is the responsibility of the national executive. Clause 231(2) states that an international agreement binds the Republic only after it has been approved by resolution by both the National Assembly and the National Council of Provinces, unless it is an agreement referred to in subsection 3. The committee thereafter should adopt a report requesting the National Assembly to ratify the said agreement. Then on the briefing on the E and F bills of the Copyright and Protection Amendment Bills. The purpose today is to consider the NCLP's amendments in relations to the Copyright and the Performance Protection Amendment Bills. This should be guided by the applicable rules, which the presentation will expand on. I now invite Ambassador Mlumbi Peter, I think, who's leading the delegation from DTIC on our first agenda item.
Good morning, Honorable Chair, and good morning to the members. I wish everyone a happy and blessed 2024. I hope you can see my screen.
Yes, we can see it. If you can just put it in slide mode.
Okay, let me do that. Thank you very much, Chair. In terms of the presentation, as you've indicated, Chair, we are putting forward the WTO Fisheries Agreement, and this is an agreement that was adopted by consensus at MC12. If I can give a brief background on the Fisheries Agreement, this was part of the Doha Development Agenda, which was launched in 2001. And then, of course, as members would be aware, we have been advancing and advocating for the conclusion of the round, but because of resistance from developed countries, we have not been able to. So the Fisheries Agreement was then given impetus in 2015 with the adoption of the UN SDGs. And then there was a lot of focus from the membership, and also this arises from the fact that you now have globally a lot of interest on environmental sustainability. And therefore, this has become the first agreement in the WTO that deals with issues of environment as well as sustainability. The agreement that we are presenting today to the Portfolio Committee constitutes what is called the phase 1 of the agreement, because unfortunately at MC12 we could not conclude all the elements that would constitute a comprehensive fisheries agreement. What it covers is only IUU, so disciplining subsidies that relate to illegal, unreported and unregulated fishing. In terms of what we mean by illegal, unregulated and unreported fishing, the illegal part happens when vessels are fishing in contravention of coastal states' law. Unreported, every vessel that is given a right to fish in the waters of a coastal state is supposed to report in terms of how much it has collected in terms of catch. So it has to submit the catch data to the coastal state so that the coastal state is able to ensure that there's no overfishing. So you have a situation sometimes where there's no reporting of how much is caught, or in some cases misreporting where the vessels underreport. Of course, these are activities that as a country and as the global village we should not support. Unregulated fishing relates to fishing in areas or for fish stocks by vessels without nationality, because every vessel that is fishing in the coastal waters or in the regional fishing areas must fly a flag so that it has to adhere with the specific laws of a specific country. So you do have vessels that fish without flying a flag that is unregulated, or they fish in areas where there are no applicable conservation measures. So all of that is what is called illegal, unreported and unregulated fishing, which is IUU. And of course, all members across the globe are committed to prohibit IUU fishing. So the agreement therefore captures that part where we have committed, all of us, to discipline and prohibit subsidies that are targeted at IUU fishing. Secondly, the other aspect covered by the agreement is fishery subsidies that relate to overfished stock. Again, if we are serious about conservation, we cannot encourage fishing of overfished stock. So the stock that is overfished needs to be given time to rebuild. Which is why all the members were committed to regulate and prohibit fishing for overfished stocks. The last part that is covered by this agreement relates to fishing in the high seas. High seas, by their nature, are no man's land. They are unregulated. So again, members committed to prohibit fishery subsidies for those vessels that are fishing in the high seas. The aspect that could not be covered by the agreement relates to overcapacity and overfishing. So it is in that regard that there is now a phase 2 that is now currently being negotiated in the WTO. In terms of the presentation, I will outline the benefits of the agreement. I will outline the fisheries agreement in terms of the 3 areas that I've outlined, IUU fishing, overfished stocks, and fishing on the high seas, and then also touch on the notification and transparency obligations that we have undertaken, and then also the dispute settlement provisions of the agreement. I will also provide the rationale as to why we need to ratify the implementation plan, the risk and risk mitigation, including whether there are any financial implications from implementing the agreement, and also benefits to vulnerable groups as well as the broader economy, and also the consultative process that we have followed as we were negotiating the agreement in the WTO. The people that are here from the DTI team is myself, as well as Ms. Nikki Krier, who is the Chief Director for Trade Negotiations in the Trade Branch, as well as Ms. Kitiboni Machiu. In terms of the benefits of the agreement, for South Africa, we believe that if we implement the agreement, this will contribute to South Africa's MTSF 2019 to 2024 in terms of priority 7, a better Africa and a better world. And it will also contribute to reducing fishing pressure on global fish stocks. As I said, this is about meeting the obligations and the commitment that everyone has made globally to the UN SDGs, and specifically SDG 14.6, which provides that we are committing to prohibit certain forms of fishery subsidies which contribute to overcapacity and overfishing, and that and those subsidies that contribute to illegal, unreported, and unregulated fishing. And we have committed with regards to IUU to eliminate those, because, as I said, it's about illegal activities, underreporting or misreporting, and also fishing in unregulated areas. We also believe that it will contribute to the National Development Plan provisions that relate to environmental sustainability, in particular, sustaining South Africa's marine ecosystem. Also, importantly, if we are contributing to a global effort to manage our fisheries and fishing stock in a sustainable manner, that will contribute to especially those communities that are dependent on fishing for their livelihood. So the coastal communities, but also subsistence and artisanal fishers that are really reliant on fishing for their livelihoods. So the reason for the presentation is that we are seeking the Portfolio Committee to ratify the agreement as recommended by Cabinet. And this is, of course, the agreement on the WTO Fisheries Subsidies Agreement. In terms of the first phase, as I said, we are only dealing with the first phase, given the fact that we could not conclude on aspects related to overcapacity and overfishing. As I said, the first phase was adopted at MC12 in Geneva on 12 to 17 June 2022. and it sets new binding multilateral rules that aim to cap harmful subsidies, which are a key factor that contributes towards the depletion of the world's fish stocks. And what we also see is that those countries that have already overfished in their waters are now engaged in distant water fishing and are targeting fish stocks of those countries who are doing their best to manage their resources. So we have a number of countries that are responsible for this, including, of course, countries such as the EU that is involved in distant water fishing. You also have China that is involved in distant water fishing. So, and those vessels are able to access other countries' waters because of the subsidies that they are given by the governments. So if you want to manage now overfishing in our waters, it is important that we find a global mechanism that will discipline those subsidies that assist these vessels to go far away to then access the fish stock. So that is the contribution that this agreement will make towards also our own efforts of managing our fish stocks much better. The agreement recognizes and provides for special and differential treatment. Honorable members, special and differential treatment recognizes that we have in the WTO countries at different levels of development. And therefore, when it comes to commitments, we need to take commitments that are commensurate with our level of development. This is a key principle in the WTO and is a key principle that is outlined in the Marrakesh Agreement. So as we're negotiating this agreement, we had to also ensure that the agreement not only complies with the mandate given under SDG 14.6, but also adheres to the principles that we have agreed to in the WTO. However, given the elements that are covered by this agreement, which of course is something that all of us, regardless of the level of development, are committed to. They need to cap IUU fishing, they need to cap fishing in overfish stocks, they need to cap fishing in high seas. So as a result, you will see that the S&D, or special and differential treatment, that is entailed in the agreement is in terms of transitional periods, because as I said, no government can be seen to be defending IUU fishing or fishing in overfish stocks or fishing in the high seas without recognizing the necessary need to conserve the fish stock. So that is why we were able to commit to the transitional period. And the transitional period is really giving an opportunity for countries that need to establish the systems to be able to implement this and go through their own internal processes to be able to implement the agreement and the obligations that arise therein, but also gear themselves in terms of the ability to report in line with the obligations and the transparency obligations that are entailed in the agreement. So the transitional period is allowed for that. And of course, in some of the countries, especially the least developed countries, they will need technical assistance and capacity building. So the agreement also provides a fund that is established for this purpose. And the countries are therefore encouraged to contribute to the fund on a voluntary basis. And the main contributors are developed countries who have an obligation to contribute to this fund, as I said, on a voluntary basis, but also developing countries that are in a position to do so. And we've seen a number of pledges from various countries towards the fund, so as to assist developing countries to be able to adhere to their obligations in the agreement. The agreement prohibits support for illegal, unreported, and unregulated fishing and bans support for fishing in overfish stocks and subsidies for fishing on the unregulated high seas, as I've indicated. Therefore, the Fisheries Subsidies Agreement that is submitted for ratification constitutes what is called a phased approach, given that the other aspect on phase 2 is still under negotiation. And it is also important to emphasize that the fact that we are now ratifying Fish 1 or phase 1 of the fisheries agreement doesn't mean that automatically we would have ratified phase 2 once concluded. And of course, the aim in the WTO is to try and conclude phase 2 of the agreement on aspects that cover overfishing and overcapacity by MC13. Of course, there is still a number of contestations in the key aspects of that phase 2. So it's not clear whether we will conclude. So once phase 2 is concluded, we'll still follow the same route in terms of ratification. The scope of the agreement covers only wild marine capture. So and also fishing related activities that are taking place at sea. It does not cover inland fishing, and it does not cover aquaculture. It also does not cover payments under government-to-government agreements. And government-to-government agreements are those agreements where a coastal state, if it feels that it doesn't have enough capacity in terms of fishing vessels to fish in its own waters, it then gives permits to a third country through a government-to-government agreement to allow the vessels of the third party to then fish in its own waters. And this is allowed in terms of the UN Convention on the Law of the Seas. So because of course, revenue implications for many of the countries that allow for this, of course, many developing countries were in support of this being carved out of Fish 1. However, I know that in the second phase, this issue is still very much contested because, of course, the countries that negotiate these government-to-government access agreements, the EU is mainly the biggest partner that negotiate these agreements, especially in the Caribbean and the Pacific. China is also doing the same. So there's a view that there are subsidies that are provided by these governments that allow even access to third parties in terms of distant water fishing, and also those subsidies will need to be brought in. But in terms of the first phase, as I said, it is currently not captured. So we'll see how that then ends up in terms of the second phase of the negotiation. But for the members' interest, South Africa does not have any government-to-government access agreements that it has concluded, because we do have our own capacity in terms of fishing in our own waters. The agreement thus includes new disciplines. 2 subsidies are attributed to the member conferring the subsidy. So it does not matter whether the member that is conferring the subsidy is a coastal state, is a flag state. All the subsidies are then captured, which aims to ensure that we have comprehensive disciplines towards, curbing IUU fishing, as well as fishing in overfished stocks. Due to the complexities in relation to the disciplines to address overcapacity and overfishing, as I said, this aspect is now being dealt, and we hope that it will be concluded towards MC13, which is to be held at the end of February 2024 in Abu Dhabi, to be specific, from 26 to 29 February, so this month effectively. So those recommendations will therefore cover additional provisions that will address overcapacity and overfishing. And this aspect is actually the more critical aspect, because it covers disciplines to fishery subsidies in terms of the EEZ, including, it has some of the sensitive aspects, such as subsidies and support that can be provided to artisanal subsistence fisheries, as well as to coastal communities. And given that it affects issues of livelihoods, there are a lot of sensitivities around this. And the other sensitive issue around the phase 2 is the fact that you have, again, countries that have a first mover advantage, that have been subsidizing their fishing vessels for years, and they have built enough fishing capacity to be able not only to fish in their own waters, but also to target others' waters through distant water fishing. Now, the biggest contestation is what elements would cover special and differential treatment, so that since we also have the Blue Oceans economy, it will be important that we don't foreclose the opportunity to build our own capacity in terms of fishing vessels, given that we have not been able to do that before. So there's a lot of discussion around how do we deal with special and differential treatment and take into account the fact that the biggest contributors towards this agreement, again, in line with the principles that relate to any aspects that have to do with the environment, that we need to have common but differentiated responsibility, and that those countries that must take the biggest responsibility are those countries that are involved in large-scale industrial fishing, and also those countries that are involved in distant water fishing, and that aspects such as subsistence fisheries should be carved out from the agreement. And this is the position of the Africa Group, the ACP, and other like-minded developing countries. In terms of the various aspects, if I can now drill down in much more detail in terms of the three aspects that are covered by the agreement. Firstly, the agreement prohibits subsidies for IUU fishing with comprehensive transparency provision. And the reason this is of benefit to South Africa and Africa is that IUU fishing costs the continent over $2.3 billion in economic losses every year. And this is according to the estimates by the African Union Commission. Therefore, the agreement provides that once a finding and a final finding or determination has been made that a vessel or an operator is involved in IUU fishing or IUU fishing related activities, and subject to that entity that is mandated to make a final determination following due process in terms of procedures and giving the vessel or operator the opportunity to make representations, and then a final determination is done. Then the subsidizing member will then be required to stop providing any subsidies to that vessel or operator. And of course, in terms of our notification obligations, in terms of the agreement, once we have a list of those vessels that are involved in IUU fishing, those will need to be notified to the WTO, and the determination will need to be notified to the WTO. So that is really the essence of what is contained in the agreement. So there has to be due process by the coastal state or the RFMO. And of course, the coastal state has the mandate and sovereign right to address issues of illegal fishing, including conservation measures in its own waters. So the agreement does not take away, therefore, the right of coastal states and give it to the WTO. So the coastal state will make a determination itself. And then, of course, we notify the member concerned that we found a vessel that you have been subsidizing that is involved in this activity. Therefore, you have an obligation to stop subsidizing that vessel or operator. And of course, the entities that can make these findings in terms of a final determination on whether a vessel or operator is involved in IUU fishing is a coastal member for areas under its jurisdiction. And members would be aware that a coastal member is responsible for managing its water within the exclusive economic zone, which is 200 nautical miles. And therefore, in its waters, it has that responsibility. As I said, the important issue was to also safeguard the rights of coastal states in their waters in line with the UN Convention on the Law of the Seas. Another entity that can make a determination is a flag state for vessels that are flying its flags. There are countries that maintain open registries that allow a vessel to take their own flag. So even those flag states have a responsibility in terms of this provision, and also to ensure that the vessels or operators flying their flag adhere to conservation measures. Another entity that can make a determination is a regional fisheries management organization or arrangement, what is called an RFMO or A, for areas and species under its competence. And of course, South Africa is a member of a number of RFMOs. These really relate to arrangements around how we manage straddling fish and fish stocks that are migratory in nature. So most of our RFMOs relate to tuna. In terms of the second aspect of the agreement, which relates to overfish stocks, the responsibility is that you need to recognize that a stock is overfished, and that responsibility rests with the coastal member for areas under its jurisdiction, and of course by the RFMO for those areas and species that are under the competence of that RFMO. The only subsidies that are allowed are subsidies to rebuild the stock, because we had to also be conscious that a member may need to take measures when the stock is overfished to ensure that the stock is rebuilt to a biologically sustainable level. So those subsidies, which are under inverted commas good subsidies, will then be allowed to assist in rebuilding the stock. The agreement also prohibits, which is the third element, activities related to areas outside the jurisdiction of a coastal member, which is the unregulated high seas. So those are the areas outside of the coastal member's jurisdiction or the RFMO, and therefore are not regulated by anyone. And also members have taken an obligation to say where we do not know the status of the fish, then members must exercise due restraint in terms of providing subsidies. Maybe before I get to the transparency obligations, I must also state that South Africa really does not provide subsidies to the fishing industry. However, in terms of the WTO definition of what constitutes a subsidy also includes not only direct contribution to enterprises, but also foregone revenue by a state. In the case of South Africa, we have a fuel rebate because everyone that buys fuel pays a tax at the pump, and we use that to maintain the roads and rebuild the roads. So for those industries that do not make use of the road infrastructure, they are allowed to claim a rebate. So because it is foregone government revenue, it is now caught under that definition under the Agreement on Subsidies and Countervailing Measures. And we have sought legal opinion just to check whether our understanding is correct, and we do have confirmation to that regard. So as we are negotiating the phase 2, we are advancing as South Africa that such subsidies, under inverted commas, are defined or are carved out of the agreement, because those subsidies are not necessarily about subsidizing the cost of fuel, but it is because the industry is not making use of the road infrastructure, and as a result, it gets that rebate. And we're not the only country that has similar arrangement. I think many countries, the EU, India, and everyone has that type of fuel subsidy, as I said, under inverted commas. So the discussion is now taking place in the WTO around how we treat such a subsidy. And if we are including, because you have India and China that are advocating for inclusion of a fuel subsidy and for it to be prohibited under the phase 2 agreement. Now, the question would be, how do you define a fuel subsidy while taking into account that you have some subsidies that are not necessarily about subsidizing the price of fuel, but the rebates that I've referred to. So the discussion is ongoing. And of course, you will see that under the consultation process, we have been consulting with the industry as the negotiations are taking place. In terms of the notification and transparency obligations, of course, as part of this agreement, we have undertaken new notification and transparency provisions. And again, if members look at the agreement, there's a special and differential treatment built into the transparency provisions, that there's less regularity in terms of reporting by developing and including least developed countries. And the developed countries, which are the biggest subsidizers, of course, are reporting more frequently. So that element has also been built into the agreement. It's important to also note that we are a member of a number of fisheries international organizations, as well as RFMOs, as I said, and we have been complying with the notification provisions that are similar to what is now entailed in the agreement. So we don't necessarily foresee that there will be a difficulty for South Africa in terms of complying with its notification obligation. And this has been confirmed by also the Department of Environment, Fisheries and Forestry, but also by the legal opinions that we have sought from both the Department of Justice as well as international relations. And of course, also part of our domestic laws and policies satisfy the notification requirements for transparency purposes. And the information that is expected to be included in the notification is the type or kind of fishing activity for which a subsidy is provided, and to the extent possible, the status of the fish stock in question, the catch data, fisheries management measures that are implemented for the fish stock in question, information on vessels that are benefiting from subsidies, and a list of vessels and operators that the notifying member has made a determination that those either vessels or operators are engaged in IUU fishing. In terms of the dispute settlement provisions, well, there are dispute settlement provisions that are part of the agreement, and effectively a member that fails to adhere to the new disciplines will be in line with normal practice in the WTO, be brought to the WTO, and the agreement, of course, brings for the first time issues of fisheries management within the scope of the dispute settlement system of the WTO. Of course, members would be aware that we are still struggling with the dysfunctionality of the dispute settlement system, with the US not agreeing to the appointment of the appellate body members. So the first phase, which is the panel phase of the dispute settlement system, is still functional. However, of course, this appeal system is the one that is not functional. Therefore, members are appealing into the void, which makes the resolution of disputes a bit of a challenge in the WTO, unless the two members find common ground in terms of how to deal with the dispute without necessarily invoking the appeal system. In terms of the need to ratify, maybe let me start by saying currently we have 52 members that have ratified the agreement and have submitted their instruments of ratification to the WTO. For the agreement to come into force, we need 110 ratifications. So members can see that we are still very far apart in terms of meeting that quantum of ensuring that the agreement enters into force. Of course, there's a lot of push as we are approaching MC13, because this is also seen as one of the possible deliverables for MC13. And at MC12, members did commit to ensure that we will go through ratification processes and ensure that the agreement enters into force. So even though, yes, there's still a long way to get to 110, the DG is also approaching a number of members that have not yet ratified. The General Council Chair has also been sending letters encouraging members to ratify, and the DG has also sent letters to the speakers of parliaments. So there's a lot of push to have the agreement ratified. As I said, where we'll end up at MC13 remains to be seen. And once the agreement enters into force, to build a bit of impetus to the conclusion of the phase 2, which is also one of the important aspects to have a comprehensive agreement, is that if we don't conclude phase 2 within 4 years of the agreement entering into force, then the agreement automatically lapses. So there's also, as I said, a bit of pressure to conclude the phase 2 so that we avoid also getting into a challenge with the agreement lapsing because that aspect has not been concluded. In terms of the rationale for ratifying, I think for any country, and given the aspects that are covered by the phase 1, the fact that no country can be seen to be supporting IUU, no country can be seen to be supporting subsidies that are targeted at overfish stocks, no country can be seen to be supporting and providing support through subsidies to vessels or operators fishing in the high seas, which are unregulated areas. And therefore, there's a moral and reputational risk for not ratifying. But also importantly, for us, the biggest contribution for this is that individually, it's very difficult for any member to fight these subsidies because the subsidies are provided by a third party, and therefore it's very difficult as an individual country to discipline those subsidies. So a global multilateral framework to discipline these subsidies is the most effective mechanism to ensure not only sustainability of global fish stocks, but also our stocks, because if we can manage to cap these subsidies that allow vessels coming from third parties to access our waters and even engage in such activities as IUU fishing, therefore this agreement will by implication assist us in our conservation efforts of our fish stocks. And of course, it will also assist us to ensure that the coastal communities continue to have access to the resources that they need for their livelihoods. So for that reason, we do see a need for the ratification and the entry into force of this agreement, because it's only an international instrument that can really assist us in dealing with the issues of overfishing in our waters. In terms of implementation, most of the issues, as I've indicated, are already covered in a number of international treaties that we are a member of. South Africa is a member of the Port State Measures Agreement, which already includes obligations and measures that need to be implemented to combat global IUU fishing. So as a result, what is now entailed in this agreement is not necessarily that much new because we are already implementing this. And as I said, also in terms of domestic law, we are already in compliance with most of this in relation to the Marine Living Resources Act, Act 18 of 1998. And also, as I said, the legal opinions also confirm that there is nothing in this agreement that is contrary to our own domestic laws or also our international treaties. And therefore, we do request Parliament to consider ratifying the agreement. And of course, the Department of Justice and Oxley have also confirmed that the nature of the agreement requires that it is ratified in terms of Article 2312 of the Constitution. And of course, once ratified, then South Africa will deposit the approved instrument of acceptance with the WTO. In terms of financial implications and risks, there are no financial implications from what we could assess, including with the Department of Environment, Forestry and Fisheries, which will be responsible for implementing this agreement, because, as I said, most of the provisions are in line with either national law or the international treaties that we are already a member of, or also in terms of the RFMOs that we are a member of. In terms of risk, the only risk that we see is that given, as I said, the moral and reputational rationale of implementing the agreement. If we don't implement, then there's a bit of credibility as a negotiating partner, but also as a responsible fishing nation, that we are now not part of an international mechanism that aims to deal with the activities that I've already referred to. And secondly, given that a number of countries and of course most and key trading partners of South Africa are taking measures to really promote issues of environment and sustainability, we do anticipate that going forward, for our fish products to access these key markets, there could be measures that are taken against those who are not adhering to these global standards, if you will. So we don't want to get to a point where those measures are enforced, and now we have to grapple at the last minutes to ensure that our products continue to access. So it is also in that regard that we believe that is a mitigating measure of that possible risk. That it is important for us to ratify the agreement. In terms of support and benefits for vulnerable groups and the broader economy, as I've indicated, this is the most effective tool because, as I said, individually, it will be very difficult for us to discipline fishery subsidies. So this is the most effective global tool and global standard for ensuring that we have better fisheries management. It will strengthen South Africa and global sustainable fisheries management system through the transparency requirements that are entailed in the agreement. And it will also improve data collection on the stock status, especially of vulnerable fisheries and related subsidies. And if we're able to discipline the fishery subsidies, but also through this agreement carve out small-scale fishers and subsistence fishers, then we would be able to ensure that there are better mechanisms for fisheries management, including those that would support the fisheries community. But as I said, the critical issues that relate to support for subsistence and coastal communities is what is now being discussed under the second phase. So it will be important for South Africa to be vigilant that there's nothing in the second phase agreement that will then affect the rights of coastal communities in terms of accessing the waters. And of course, it is important to ensure that a well-managed fisheries industry is able to assist in terms of providing livelihoods, but also predictable income opportunities. And that can only happen if we are able to have an effective mechanism that can support the conservation of the fish stocks. Also important is that as we were negotiating phase one, and we are doing this as we are negotiating phase two, what we want to ensure is that we are able to have an agreement that continues to preserve our rights in the exclusive economic zone, and that there's nothing in the agreement that should constrain our efforts to manage our waters, and that there is overreach by the WTO in how we manage our EEZ. So that is, there's nothing now under phase one. As I said, all of those aspects will come under phase two, and South Africa will therefore need to be vigilant there. In terms of our consultative processes, the agreement has been finalized in consultation with the Department of Forestry, Fisheries and Environment. In fact, they have been working hand in glove with us, participating in the actual negotiations in the WTO, because we needed to make sure that there's nothing in the agreement that would have a negative impact on South Africa. And of course, this has been now confirmed by the two legal opinions. We also worked with the Department of Transport. Consultations also included consultations in NEDLAC. We also worked with SASTIA, the South African Deep Sea Trawlers Industry Association. We did also reach out to the coastal communities, but because it's very difficult to consistently engage them. We have been inviting them in the meetings that we're having with the industry, but what we struggled with was consistent participation of the subsistence and artisanal sector. but their issues are coming more under the phase 2, and the department, including DEF, will need to ensure that we are continuously engaging also the small communities on issues of their interest. Therefore, the recommendation is to present this for ratification to Parliament in terms of Article 2312 of the Constitution. And of course, once ratified, the instrument of acceptance will be submitted to the WTO. I thank you, Chair.
Thank you very much, Ambassador. Members of the committee, there we have the presentation. I'll take hands for interaction with the presentation. There we have it. Okay. So we have Honorable Bergman, McPherson, Mulder, Thring.
Mr. Thring.
Yeah. Thank you. Honorable Bergman, you may proceed.
Thank you very much, Chair. I know we can't change anything in the actual wording, but I've just got a concern in terms of the parties to the treaty, those that actually aren't party to the treaty, those countries that come to our shores that would actually then still engage in illegal fishing off our shores. We quota those that are loyal to us, but then there are those that still come to our shores and fish off our shores, poach what we have. So let's say in numbers, for argument's sake, we can only fish 5 fish per boat. They come and take 100. There's no controlling them. Now, for argument's sake, I had an interaction with one of the ministers of Ivory Coast who proudly told me that they get 50% of their fish imported from China. And then I showed him on one of the apps that most of the Chinese boats, the fishing trawlers, are actually trawling off his coast and getting the fish from his coast. Now, I know that we're saying that there's a sanction whereby you can go to, let's say, China, for instance, and say to China that you can, not to subsidize such a boat. But what if this is one of these boats that are illegal? Now, again, we're punishing, what happens, we tend to punish those that are compliant, and those that are illegal get away. So these treaties have a controversial impact on those that are compliant, and then don't really have any impact on those that are actually still poaching. Thanks very much.
Thank you, Honorable Bergman. Honorable McPherson.
Thanks very much. And hopefully, Ambassador, we'll see you in a couple of weeks' time in Abu Dhabi. Ambassador, I just want to, if I can ask around sort of, you mentioned one of the outcomes that you're hoping for MC13. And it seems that I think when we were last there with you in Geneva last year, there's, a continued frustration around, the mechanism of the WTO and its sort of stalemate and actually dealing with some of the very serious issues. So we sort of try and sort of pick and choose the easy ones just to try and show something that's being achieved, I guess, to try and, maintain the relevance of the WTO. I would just like your thoughts or comments around sort of, and also your insights into where you think that MC13 is going to go, and whether there is going to be some shifting in the way in which the body is working, and whether there's going to be some really big highlight deliverables. Thanks, Chair.
Thank you, Honorable Mulder.
Thank you, Honorable Chair. I'm taking note of the fact that South Africa played a key role in negotiating the agreement, and we welcome the text also realizing that the text couldn't be changed at this stage, my question would be whether the Commissioner would think that will be of opinion that South Africa has got the capacity to implement the agreement effectively. Because after the text and everything has been approved, that's what's lying ahead of us. Has South Africa got the ability and the capacity to implement this agreement effectively? Thank you, Chair.
Thank you very much. Honorable Thring. Honorable Thring, you must unmute yourself.
Thank you, Chair. I think I may be having connectivity issues because I lost the Honorable Mulder towards the end. But let me go quickly into my questions. Chair, firstly, appreciate the presentation from the Ambassador, but she mentioned at the beginning that there was resistance from developed countries to the regulation. Why was this so, and how was it overcome? My first question. The second question is how is overfished stock determined and by who? And I think it was that the who part was answered, but the first part of the question is how is overfished stock determined? Thirdly, how effective are our regulatory enforcement arms in South Africa in preventing other countries from plundering our fish within our territorial waters? And then lastly, what penalties are there for countries that are either guilty of the IUU fishing, and secondly, those countries that refuse to stop subsidies to the guilty parties? So what are the penalties in that regard? Thank you, Chair.
Thank you. Honorable Dr. Ntwane.
Thank you, Chair. Chair, I want to commend the Ambassador on the presentation made to the Portfolio Committee, which was quite comprehensive and explanatory. And I want to, I don't think, maybe I've got one question, but I just want to make a comment to say that since this Doha Development Agenda was launched in 2001, the fact that we are able to have this agreement on our table today, it's quite commendable, considering the resistance that developed countries gave to this process. Then I want to now ask a question. When South Africa deposit the approved instrument of acceptance to the World Health Organization, considering that 52 out of 110 members has ratified the agreement up until now, will we be able to implement the IUU enforcement protocols? And then I want to just also mention that I want to commend the possibility of considering our fishing communities, because at the end of this, at the end of the day, they are the ones at the receiving the worst from overfishing and illegal fishing in our waters from subsidized fishing trawlers. Thank you, Chair.
Thank you, Honorable Ntwane. I think you mean WTO and not WHO.
Sorry, yes, WTO. My apologies.
Okay. Thank you. Honorable Monakedi.
Thank you, Chair. Dr. Ntwane has, in the main, covered the points I wanted to speak to. Safe to comment the department for taking a leading role in these processes and making sure that as South Africa, we are counted amongst the countries that are serious as far as issues of global sustainability are concerned. I also want to commend the department for ensuring that they go out of their way to bring on board coastal communities as far as these processes are concerned. Of course, it has been clarified that the issues that are going to affect them the most are issues that are going to arise in phase 2. And I want to believe that concerted efforts will then be made to ensure that they are conducted, there are processes and assistance given to them so that they are able to participate effectively and influence the direction and the outcomes of those particular processes. My last point is on this, the number of countries that have assented or ratified the agreement. The indication is that there are 52, and the required number to bring the agreement into operation is 110. I just want to check, are there some sticky points, perhaps, that the remaining countries that still have to sign are raising, or is just a matter of processes that have to be gone into in their own individual parliamentary or government processes? Thank you very much.
Thank you. Ambassador? Is Ambassador still on the platform, Andre? Oh, I see she is. Please just unmute yourself.
Oh, thank you, Chair. Sorry about that. In terms of the questions by Honorable Beckman, I think the issue here is that you can try as much as you can to deal with those countries and members, including the vessels that are involved in these illegal activities. I think research shows that the biggest contributor or the biggest driver of especially vessels or operators involved in distant water fishing is subsidies. So what this agreement tries to do is to close the tap that allows these vessels to go far and wide to access, especially our waters. Of course, I don't think the agreement will be foolproof in terms of addressing all the illegal activities. So we also have a responsibility as the coastal state to do what we need to do. And of course, our own laws, including the Marine Resources Act, does indicate measures that can be implemented if we do catch a vessel or operator that is engaged in these illegal activities. So it will have to be a combination, of course, of the WTO agreement, but also of our own internal processes to deal with illegal activities. But of course, the biggest contribution, as I said, coming out of this agreement is to close that tap, because it is clear, at least from research that has been undertaken, that it's these subsidies that are the core driver. So hence the target is to deal with the subsidies. But of course, this agreement will have to be complemented by other conservation measures for it to be effective. In terms of Honorable McPherson, looking forward to seeing you in Abu Dhabi. You're right that the WTO is still stuck in a way. One, we have not been able to deliver on what was supposed to be the promise to developing countries to have an inclusive multilateral trading system that provides balanced rules that ensure that we take commitments that are commensurate with our level of development. And of course, as we're going through the Doha Development Round, we had identified as developing countries, including South Africa, very active in that process, identifying those critical aspects that would need to be rebalanced for us to have the policy space to be able to industrialize and to be able to change the structure of our economy. And of course, address the inherent imbalances in the WTO rules. However, the WTO has not been able to move significantly on those aspects. And members would also recall that we had the single undertaking where we had agreed that nothing is agreed until everything is agreed. But since I think Nairobi, we have now moved somewhat away from that principle. And now we are looking at quick wins. And those quick wins sometimes are not the most substantial issues that will really unlock the development that we want, but also address in a fundamental way the imbalances that we see in the system. And of course, one of the critical issues of importance to us is the agreement on agriculture, where you again have huge subsidies that are provided by developed countries that really displace our products, agricultural products, not only in international markets, but even in our own countries, because our producers are not able to compete with subsidized products that are coming from elsewhere. So as a result, yes, there is that tendency to have quick wins and identify agreements that will save the system. And saving the system, of course, sometimes doesn't mean saving ourselves as developing countries, including South Africa. So what we have been trying to do, and it's a very difficult operating environment, given now the fact that you do have a number of factors that are coming at play that have put many members, including developed countries, under pressure in terms of responding to the needs of their own population. You see a rise in the unilateral measures that we see, whether under the guise of the environment, but also huge subsidization by those that have huge pockets, which again create further imbalances in the system. So there is an element of that. But of course, I think even when we look at the overall picture, while we are not happy with the WTO, and of course there are aspects that need to be reformed in the WTO, there are aspects that need to be corrected with regards to how the WTO functions. But what is clear is that having a global trading system with multilateral rules, of course, we'll still have to fight for these rules to be rebalanced, is still good for South Africa. But of course, as I said, the critical issue is to push the reform. In terms of MC13 and whether we see that there will be a significant shift, I'm afraid we are unlikely to see a significant shift for a number of reasons. A number of countries globally, I think the statistics were saying 70 countries are going to elections this year. So it's a very difficult time, including the major players are going to elections. And history tells us that in an election year, it's very difficult for members to commit on aspects that require serious compromises. So on the most difficult issues, I think it's going to be very difficult to see forward movement. I was speaking to our ambassador now in the WTO, Ambassador Gobo, to get a sense of where he sees things. The package is still unclear. Where there's going to be some positive outcomes in terms of Abu Dhabi would be accessions. We're expecting 2 new accessions, Comoros as well as Timor-Leste. And then there's expectation that ministers will also bless what was agreed in December, which is not a huge package, but it is best endeavor language and a commitment by developed countries to ensure that they extend preferences that are granted to LDCs to graduating LDCs, so that at least there's a bit of a transitional period to give them the ability to withstand the shift from being LDC to being developing countries for a limited time frame. As I said, that is also best endeavor, not really that there is firm commitment from developed countries in terms of the unilateral preferences that are granted to LDC. So those will be the two positive things, but on such aspects as TRIPS and the extension of the MC12 decision to diagnostics and therapeutics, there's huge resistance. We had put forward also policy space for industrialization so that we can have specific rules that are rebalanced to provide a policy space, especially for African industrialization. Even that is receiving a lot of resistance. There are discussions on WTO reform, but also very much contested. And of course, now we see new SPS measures that are implemented. We want to also bring that to the table at MC13. That is also resisted, especially given our experience with citrus, Amarula, especially in relation to the EU. So even that is resisted. So in a nutshell, I think it will be a very small package, even when it comes to the second phase of fisheries subsidies. It is unclear that we will be able to conclude the negotiations, still very much contested. Agriculture, there's huge resistance. So again, we will have another ministerial conference with no outcome on agriculture other than a declaration and nice English to say we're committed to the reform of the agriculture subsidies, but without necessarily firm outcomes. So I hope, Honorable Macpherson, I'm giving you a picture of the fact that it's not going to be earth-shattering outcomes, but a small package that may have some positive signals, including work programs on those aspects that cannot be concluded. With regards to Honorable Mulder, whether we have capacity to implement the agreement effectively, given what the Department of Environment, Forestry and Fisheries is saying, it seems, yes, we will have the ability to implement the agreement, given that already we, in terms of our domestic law, we are adhering to the obligations. And secondly, we are not a provider of fisheries subsidies. And thirdly, of course, I think there's always a need to continue to ramp up our monitoring capabilities in terms of what is happening in our waters. So that is a continuous fight that we have, whether with this agreement or without the agreement. The issue is a need to better manage our waters. So that work has to continuously happen, including adopting new technologies in terms of better surveillance on what is happening in our waters. So in terms of standard reporting, yes, we can, but of course, the biggest issue is to ensure that we are able to pick up these illegal activities and the monitoring systems, our conservation measures, and the ability to implement those will have to be something that we continuously aim to improve. With regards to Honorable Thring, the resistance I was referring to is not necessarily with regards to this agreement, but the DDA broadly, which is what delayed the conclusion of this agreement between 2001 and 2001 and 2022. So that was the issue, because we had that single undertaking that nothing is agreed until everything is agreed. Now that we've moved to agreement by agreement and issue by issue state now, and as well as with the biggest commitment by developed countries to issues of environment, and also the approval of SDG 14.6 or the SDGs broadly, brought momentum towards the conclusion. So there has been a lot of commitment by the developed countries to issues of environment, including fisheries subsidies. Of course, their biggest issue is the fact that and I think this is what has brought them to the party, including with regards to this agreement, in that now you have other developing countries that are able to provide huge subsidies, such as China, your Indonesia's. So now there's a bigger impetus globally to see how do we manage fisheries subsidies, because now China has built so much capacity that it's able to compete with Europe, with the US, in the waters that ordinarily were for the preserve of these countries, especially EU, given the colonial links. So given the contestation now in terms of who accesses the waters of the third countries, then there was a lot of motivation towards the conclusion of the agreement. How is overfish stock determined? Well, we have a number of systems that DEF uses, including checking the biologically sustainable level of the fish stock. They also look at sometimes the size of the fish, and then you can see that it is becoming overfished. So they're both traditional as well as scientific measures that are being used to determine whether a stock is overfished. And of course, the catch data also assist to check whether the stock is at risk of being overfished. So in terms of this agreement, it does not only look at one quantum, because that was one of the contested issues in the negotiations, because most of developing countries are relying on traditional systems where the fishing communities have their way of managing the fish, and also looking at traditional mechanisms such as monitoring the size of the fish to see that it is overfished. And then, of course, for specific seasons, they stop fishing and move elsewhere to fish. So the agreement had to accommodate both the scientific ways of making a determination, as well as the traditional ways of making a determination. In terms of the effectiveness of our regulatory systems to address these illegal activities, as I said, I think we could, continuous improvement is always important, because some of the vessels and operators use sophisticated mechanisms to overfish and to catch the fish stock. So it's important to ensure that our regulatory system is able to keep up to these. For example, there are fishing gears that are used that now actually take the fish stock, in a huge way. Our Department of Environment, Forest and Fisheries, through also the global multilateral platforms, is banning some of these as a way of managing the stock. So it is a regulatory, it's a continuous process of improving your regulation. So we can't say our regulatory system is foolproof. It always has to catch up to the new technologies that are now being used by the operators and the vessels. And we do have, in terms of domestic law, penalties that we can implement once we find that we have made a determination that there is IUU involved or there is overfishing involved. So permits are taken from those vessels or operators that contravene, and sometimes fines are imposed. So there are effective mechanisms of addressing this. But of course, what the WTO agreement does is an added layer to ensure that you have an enforcement system at a global level and a transparency system at a global level that will force the subsidizing member to stop those subsidies. And of course, if they are not stopping the subsidies, even after we have informed the subsidizing member, and we have informed the WTO, and the member is still not stopping the subsidy, then there are dispute settlement mechanisms and provisions within the agreement that can be followed up. Of course, as I said, the issue now is the dysfunctionality of the dispute settlement system. But I think, given the moral obligation and the pressure from even our own internal populists to adhere to conservation and environmental issues, I think there will be that moral pressure for any country that is involved in these activities to really stop the subsidies once these final determinations are done. But of course, I'm sure the subsidizing members and who are the culprits will always try to find mechanisms to delay this as much as possible, which is why they had insisted on due process. So I'm sure they will challenge our processes in making those determinations, but at least in the agreement, we've been very clear that the right to make the final determination cannot be interfered with by the subsidizing member. The right to make a determination is by the coastal state, the flag state, as well as the RFMO, 4 areas, of course, under their jurisdictions. Honorable Dr. Ntwane, I definitely agree that we will and we continue to engage the coastal communities as well as subsistence and artisanal fisheries to ensure that their interests are taken care in terms of this agreement, and that and of course our position is that they need to be carved out completely, because research again shows that what contributes to overfishing and overcapacity is not people who are fishing for livelihoods, because even their vessels, even their fishing gear is not sophisticated enough to contribute to overcapacity and overfishing. What is important is to really target those activities that have been proven to contribute to overfishing and overcapacity. And it is clear, it is distant water fishing, it is also large-scale industrial fishing. So our view as South Africa, the Africa Group, the ACP, and other developing countries is that we need to target the disciplines, especially for phase 2, because for phase 1, given the type of illegal activities that are covered, no one could really defend that aspect. But when it comes to overcapacity and overfishing, we are saying the disciplines have to be targeted to, as I said, distant water fishing and large-scale industrial fishing, which will then completely carve out the fishing communities, the coastal communities, who are really just fishing to make a living. In terms of the last question on the sticking points that are affecting the slow ratification. One, I think members have to follow their own national processes. So that is the issue. And actually, this is what, in fact, it's the first agreement where we've seen so much movement in terms of ratification. Even the number, yes, it's 52. But it has moved very fast in terms of WTO standards. Normally, it takes 3 to 5 years for the agreement to come into force, given the processes that members have to follow. But also what was important was the fact that many members needed to engage in the process, and also South Africa, we are in that position that we need to assess, and there was a lot of discussion to say what will be the relationship between Fish 1 and Fish 2, and how will they come together. So that clarity was important. And what does ratification of Fish 1 mean for Fish 2? So we needed to resolve all of those issues first before you ratify, so that you don't find yourself having ratified and then other provisions then come to the table. So that was the main issue. Now, with those clarifications, a number of members are following due process, but some are saying their processes are so complicated that it requires, they think that it's better to ratify once instead of ratifying Fish 1 and then going back to ratify Fish 2. So they would rather ratify. So there are a number of reasons why members are therefore taking the time. I think I've responded to all the questions, Chair. Thank you so much.
Thank you very much. Committee Secretary, can you just brief us on the way forward?
Chairperson, we at the end of the process, we can adopt the draft program. It's a draft report on the matter. And if I may ask Margaret to flight the chair, it's a standard report that you normally adopt after the process, given the fact that we can't change anything to the agreement, Chair.
Thank you.
Chair, shall I read through the report, through Chair?
Yes, please.
The report of the Portfolio Committee on Trade, Industry and Competition on the World Trade Organization's Agreement on Fisheries Subsidies dated 6th of February 2024. The Portfolio Committee on Trade, Industry and Competition, having considered the request for approval by Parliament on the World Trade Organization's Agreement on Fisheries Subsidies, recommends that the House, in terms of Section 2312 of the Constitution, approve the said agreement. The report to be considered, Chair.
Thank you very much. Members, there we have the resolution that we must pass as a portfolio committee. Can we have a move and a seconder for the adoption of the recommendation as tabled? Honorable Mbuyane.
Thank you very much, Chairperson. I propose that we adopt the recommendation and also the report as it presented by the department. Thank you.
Thank you. Dr. Ntwani.
Chair, I second the report and the adoption. Thank you.
Thank you. I think that concludes this
Chair,
agenda item. Yes.
Chair, just may I request if anyone is
Okay.
Yeah.
Can we then just check whether there are anybody, if any of our PC members wants to vote against this recommendation that the resolution that we passed, or wishes to abstain? It seems as if we have agreement. Thank you very much. Thank you very much, members, and thank you, Ambassador, and your team for this presentation. And we will now break until 10:30, and then we will resume our meeting with the next agenda item. Thank you very much.
Chair, are we breaking till 10:30? It's 3 minutes break.
Oh, is it? It's okay. Yeah, no, sorry. My maths is not good today. I say, okay, let's break until 22:11.
No problem. Thanks.
Thank you. Hi, members. Back from your tea break. I hope it was a good cuppa. Can I now hand over to Advocate Charmaine van der Merwe to take us through the E and F bills of CAB and PAB? Advocate?
Thank you, Chairperson, and good morning to all the members. I'm going to share my screen. And I am going to put it on a slide view. So I hope. Can I just confirm, are you seeing a full screen slide? Because on mine it now shows over two. Thank you very much.
Thank you.
Thank you. So what I will be presenting is the NCOP amendments on these bills, both on copyright and the performance protection. Just so that we are all on the same page, what would be expected from the Portfolio Committee? Remember, this is now the Portfolio Committee. In fact, this bill is quite complicated because it has been referred back by the President. Portfolio Committee considered it, passed by the Assembly, then went to the NCOP. NCOP made amendments, and now it is back with the Portfolio Committee. So the joint rules are quite clear. What must happen is we need to look at the NA rules for this, and the committee must confine itself to the amendments that are being proposed, and the committee may not propose further amendments, but the committee may consult the select committee if there's anything that is not clear. So in other words, just to sum it up, the committee will have to consider the amendments that were made by the NCOP, to report thereon, and then make recommendations on those amendments. If it is deemed necessary, the committee may in fact consult the select committee. There may be no further amendments to the bill, and if any of the amendments made by the NCOP require a change in classification, the joint tagging mechanism can be consulted, but that of course will not be necessary. When I go through the amendments, I will be dealing with the legal matters and the department with the policy matters. Members will see that the amendments are really technical in nature. They do not affect classification. They do not render the bills constitutional or procedurally out of order. There's no need to consult with the joint tagging mechanism. I will also a bit later on speak to other processes that may be required and that I'm of the view is not required in respect of this bill. So if I may start on the copyright amendment bill. As I said, the department will brief the committee on policy matters. So the policy matters will relate to royalty and equitable remuneration, deleting the definition of broadcast, the issue of ownership after the word assignment, and rates and tariffs in respect of resale royalty rights. Most or a large portion of the amendments that are legal in nature is from the case of Blind SA versus the Minister of Trade and Industry. I've not yet had a chance to brief this committee on this judgment, so I would like to have that opportunity to indicate to the committee what the court's findings were, because they inform a number of the amendments on the Copyright Amendment Bill. So what the court found is that, and remember now, the court didn't make a finding on our bill. The court made a finding on the Act. So what the court found was that Section 6 and 7 read with 23 of the Copyright Act are unconstitutional because they are invalid and inconsistent with the rights of persons with visual and print disabilities. And the court went into a number of rights that are actually being infringed upon. And the court then found that insofar as the Copyright Act limit access of such persons to publish literary works and artistic works that are included in the definition of literary works in accessible format copies, that is where the Act is unconstitutional. It was suspended for 24 months. Suspension lapses in September of this year. And the court also provided a read-in measure. I don't think I'm going to go into much detail on the rights. Members do have the slides, but the rights that the court indicated are affected by the fact that the Act does not allow access in one form or another to people with visual impairment, include equality and unfair discrimination, because it becomes an instrument to disadvantage a class of people who have the same need for access. Human dignity. The court indicated that the compromise in the access is in fact places an indignity on such persons. Freedom of expression, education, and I know the committee discussed education a lot, not just in respect of the visually impaired, and also cultural rights. The fact that there is no access means that there's a compromise in respect of people's enjoyment in their rights to participate in cultural activity. So the court also considered other possible remedies. One of them was that Section 13 of the Act, which provides for regulations, could be used to provide such access to persons with a visual impairment. And the court said that this would not be able to work because an accessible format copy could also include an adaptation of a work. And Section 13, I put the wording there, speaking about reproductions only, is just not sufficient. It needs to be reproduction as well as adaptation. It was also proposed to the court to look at the wording of clause 19D, and 19D is a clause that deals with access for persons with a disability. And the court indicated that because the wording of that clause is broader, it could not be used. So maybe if I can just hold here, I will speak to it again, but just to point out that the court is limited to the facts before it. So the court was looking at visual impairment, visual disability, and literary works. That is what the court was limited to. Now, what we have done in the Copyright Amendment Bill is that all disabilities have been taken into account, because remember that for the committees looking at this bill, we need to look at the Constitution. We don't only have persons with visual impairment in front of us. We have all persons with impairment in front of us. And there could be some adaptation or some reproduction that could be made in an accessible format copy with persons with a different type of disability. And therefore, they needed to be provided for as well. And then, of course, definitely not only in respect of literary works, because it could be a different type of work that is required. I'm not going to read the read-in. It is there if members do want to have a look at the read-in from the court. But what I can confirm is that when the Select Committee considered this, there was in fact consultation with Blind SA themselves, with Section 27, who supported Blind SA in that litigation. And the final wording, they in fact agreed that the final wording that is being proposed by the NCOP does accord with the court's read-in, but of course taking into account that it is broader to include all types of disability and all types of work. So this is now what I've explained before, that the differences between the bill and the read-in is mainly on drafting practice and policy. The court could not consider other types of disability, although other persons of disability are also being affected and their rights are also being affected. The Marrakesh Treaty states in Article 12 that a contracting party may implement its national law, also implement other copyright limitations and exceptions for the benefit of beneficiary persons that are provided by this treaty. This treaty is without prejudice to other limitations and exceptions for persons with disability provided by national law. So then I'm just saying there, also in consultation, these amendments were then proposed. So now I'm dealing specifically with the amendments that this committee will have to consider. So the first definition was accessible format copy and person with a disability. And there was an agreement in the committee, in the NCOP, and as I said, Blind SA also were in agreement that there are no amendments required to that definition. However, the definition of authorized entity, now, from my legal interpretation, I do not see that there is a problem with how the bill read. But Blind SA was concerned that the definition as it was in the bill could in fact be interpreted narrower than the read-in of the court and the treaty. So in order to accommodate that, the committee, the SC committee and the NCOP approved that the definition be amended to read an entity, comma, including, and then the normal definition. I was a bit concerned that this may be too broad, and therefore I also brought in what the court had as part of its read-in, and which is also provided for in section 19D, that it must be on a non-profit basis. So in other words, we are broadening it a bit by saying an entity, including a government institution or non-profit organization, but we then limit the word entity by confirming it must be that they do this work on a non-profit basis. Then in clause 22 itself, this is the clause that deals with section 19D. The first subsection there, that I must admit was really an error, a drafting error. And I don't think that I was ever instructed to have the word authorized entity be subject to regulations. So it is simply an interpretation matter that is being corrected here. So what is happening now is that the bill, as it was considered by the portfolio committee, indicated that any person as may be prescribed and who serves persons with a disability, including an authorized entity. So the argument was that because including an authorized entity is after the words any person as may be prescribed, that had to be included in regulations. Now, that was not the intention. It is an interpretation issue, and we could easily fix it by just swapping it around. So, and the proposal then for amendment, and that was accepted by the NCOP, is that it should read an authorized entity, which is defined, remember, or any person as may be described. So now it reads correct. Authorized entity, you will look at the definitions to see what this would be, or a person as may be prescribed. So that is now how that reads. In respect of subsection 2, there were no proposals for amendments, but there was an insertion of a new subsection 3. And the problem is that subsection 2A seemed to require that a new accessible format copy must be made every time. The court, the reading, actually allowed copies to be made from an accessible format copy that a person has lawful access to. In other words, subsection 2A appears to require that your accessible format copy must always be made from the original, which of course is clear is going to limit access. That is simply not something that is possible. It's not the purpose of making the accessible format copy. So the insertion then of the new subsection 3 is that a person with a disability or someone acting on their behalf, including an authorized entity, may make an accessible format copy of a work for the personal use of the person with a disability. That's very important. For the personal use of the person with a disability, or otherwise may assist the person with a disability to make and use accessible format copies where the person with a disability has lawful access to that work or a copy of that work. So in other words, this now says that the person with a disability or someone who is acting on their behalf, or they may be assisted to do so, they may make and use accessible format copies if they have lawful access to a copy of that work. So, yeah. Then subsection 3, of course, then becomes subsection 4. So that's just a consequential amendment. And in the new subsection 4 now, there is just a deletion of the format copy referred to in subsection 1, because if we link it there to subsection 1, we again link it to that you must have the original to make an accessible format copy. And then 4, of course, also becomes number 5. Section clause 31, so not the actual clause that deals with disabilities, but further on, clause 31 relating to technological protection measures. Blind SA also was concerned that 28P2 gives the same requirement of authorization that the court held to be discriminatory. But when I considered 28P2, I realized that 2, in fact, is not necessary. It seems that as we have amended the bill, this was a consequential amendment that we overlooked. If you look at 28P2, or rather they start at 1, it says that a person who circumvents a technological protection measure to make use of an exception allowed by the Act, then you may circumvent. So that is allowed. You're allowed to make a circumvention if it is an exception allowed by the Act. Then 2 says, you can only do the circumvention, if you can circumvent it on your own, or you can make use of a service to circumvent, and then you don't need to approach the owner. But then 2 says, if you cannot circumvent on your own, you can ask the owner to assist, not to authorize, to assist. And if the owner doesn't want to assist, you can then ask a third party to assist you, which is already allowed by 28P1. I suspect what happened is that we did not initially have the word service added to circumvention of a technological protection measure. So because we then added the word service, it became superfluous, because if you can make use of a service to circumvent, then you don't need to contact the owner at all. Why would you contact the owner? Accordingly, the Select Committee agreed that 28P2 is likely a consequential amendment. It should have been deleted, and that wasn't done, but it was as the bill developed and we included service. So the proposal is for that to be deleted, and then the changes to subsection 2 is simply consequential in nature. In other words, to subsection 3 are consequential. So subsection 3 becomes subsection 2, and the reference to subsection 2B then falls away because subsection 2 is now deleted. Those are the amendments relating to Blind SA. So I'm now continuing to clause 29, section 27, which deals with offences. And again, here is something that somewhere in our drafting, something went wrong, and it was really just technically correcting what we had there. So what subsection 5B indicates is that subject to section 28P, in other words, the exceptions, any person who at the time when copyright subsists in the work that is protected by a TPM, if you make or you know or you provide or you know that the service contemplated is likely to infringe, then you shall be guilty of an offence. But 3 is in fact allowed by 2. If you have 2 is a valid offence. So if you have 2 by itself, then we are saying an offence is an offence. We can't say that. 2 should be linked with 3. So in other words, your offence provides a service which you're allowed to do, but number 3, which you know will or is likely to be used by another person. So the proposal here, the amendment that was accepted, is to combine subparagraphs 2 and 3 so that we don't make a valid defense that the bill allows an actual offense, so that the wording, in other words, read correctly. Then in respect of 28P, what we have here is that this is simply, I think, maybe a terminology concern. So also quite technical in nature. So what 28P provided for is only exceptions. The problem is that not every lawful use is an exception. So 12C and 12D, for instance, are limitations. So if we do not make provision for 12C and 12D, something that is allowed by the bill will then suddenly become something that is not allowed. So we'll have a contradiction in our law. So the proposal was to include an act permitted by law, including in terms of any exception. In other words, simply to make it clear that anything that is lawfully allowed, and it will include exceptions, will not prevent a person from using a technological protection measure. Then in respect of clause 35 and the section 39 regulations. So this was something that the Portfolio Committee also had a lot of discussion on. A lot of comments have been made. And it again came up in the NCOP public consultations. So what we have is that the Farnham Commission in their CRC reports stated that the DTI is urged to draw up standard contracts between performers and record companies that are fair to both sides, and that the parties are to such agreements are that the parties are encouraged to use. Now, the concerns were, what we had was that the minister would prescribe compulsory and standard terms of contracts, and the concerns were raised that, but if the minister may prescribe terms, then this may interfere with the freedom of parties. Now, that was never the intention. The intention was that the contract terms that are to be prescribed would be your standard type contract. In other words, the standard elements that you will expect to see in that contract in order to provide the necessary protection, not so much as perhaps term could imply to say you must pay so much royalty, or you must pay this remuneration, or you must have this term in terms of which the copyright is assigned, etc. That was never the intention, to go into that detail. The intention was for the minister to put terms down that would indicate to persons this protection. You need to make provision for that in the contract, so that the author on the other side, the weaker contract party, is aware of their protection. So what then happened was that the NCOP proposed an amendment to change the word, to first of all delete the word compulsory. So we're no longer using the word compulsory terms, and then to change the word term for elements. Now the committee, I'm aware that the committee has received letters from two entities, NAB and I think CC. Sorry, now my screen is now full. There were two letters asking what would this standard elements for agreements then be. It's not something that is defined. But we need to keep in mind that we only define terminology in legislation if that terminology is broader or narrower than the dictionary definition. And any law student should be able to be woken up at 12 o'clock in the middle of the night, and if you say, what are the elements for a contract? What are the elements for a delict? They should be able to recite that off by heart. So elements is a word that is very well known in the legal fraternity. We all know when you speak of elements of something, what is it that you mean? So standard elements, of course, would simply mean that these elements would now become standard for a contract. So your normal elements for a contract would be that you need to agree on there needs to be an agreement of will. We want to, for instance, buy and sell a service, a product. That's the next thing. What is it that we buy and sell? A service, a product. What would be the price? When is it payable? Those would be the normal elements from a legal perspective. But what would happen with now standard elements is that the minister will then, because you will also see that paragraph CG is furthermore, standard elements is not just on its own. It is standard elements that will ensure rights or protection afforded by this act are duly provided for. So in other words, there may now be, in addition to this agreement on what it is that we want to achieve with this contract, the product or a service, the price, when it is payable, there may be an element talking about the reversal right. There may be an element talking about certain royalties that will continue to be applicable as per the wording of the act. So that is the amendment that is being proposed. In the letters, the persons, the institutions also requested for public hearings on this amendment. But this is simply a change of the wording in order to make clear what is the intention. Nothing has changed. It is the terminology making contract terms That is what the intention was all along. Changing it to standard elements was simply trying to accommodate and assuage the fears of the public that the minister may come and say, but you need to say that it's 5 years or 10 years, because that was never the intention. I've not specifically gone into public hearings on any of the other amendments, but I have mentioned that they are kind of technical, that they are simply to ensure that the interpretation of what is in the bill is in fact correct. There were some drafting errors. Now, none of those type of amendments require that this committee should call for comments. We are only required to call for comments when there is something new in the bill or some material amendment where the public has not had an opportunity to respond to. The public has had so many opportunities to respond to this. And the proposal, in fact, is then because of the comments from the public, and it is to assuage their fears and to make the wording of the bill more clear. So there is no need for any public hearings on this or any of the other proposed amendments. The short title is something that, sorry, not the short title, the commencement was something that the NCOP was quite concerned about. And also the blind SA judgment required that this be adjusted. So this is the instruction from Parliament to the President and to the Executive about when this Act will become operational. And what we had is, we had the normal sentence there. It comes into operation on a date fixed by the President by proclamation in the Gazette. And I've explained to the committee, the Select Committee, and that's why the wording is as it is, and I will explain to this committee as well. The reason normally for a delayed operational date is that there are some things that need to be put in place before the Act can be made operational. So, for instance, this Act deals with new ways of dealing with collecting societies. You can't just bring in a legislative requirement that a collective society must go and register, but you don't have the manpower to register, you don't have the forms to register, you don't have an entity where they can go and register. So those kind of requirements will have to first be prepared for in practice, and then it is brought into operation. But the NCOP felt, although they accept that, they do not want the department to sit on this for 5-6 years, as sometimes is happening on other legislation. And therefore they said, well, let's give them a deadline. So the Act will come into operation 24 months from the date of publication in the Gazette. So once the President has assented, it will be published in the Gazette. That is the date of publication. From 24 months from that would be the operational date. Or if the department is ready earlier, an earlier date fixed by the President by proclamation in the Gazette. So that is what that requires. And then specifically, because we acknowledge that there could be this gap that is required to make this bill operational, but we have to address Blind SA immediately. That order, we need to have that operational in order to not interfere with the rights of people, because if we wait for this bill to only become operational in 2 years, we will have a period of about 1.5 to 2 years, depending on when this is passed, where these rights will be affected, because there will be no bill operational and the read-in stops in September. So then the proposal was to make it very clear that the definitions for accessible format copy, authorized entity, and person with a disability come into operation on the date of publication, and so will Section 19D. Okay, then I'm proceeding to the Performance Protection Amendment Bill. On this bill, the DTI will brief the committee on the deletion of the definition of broadcast. It's the same rationale as with copyright, but they will still brief the committee on that. And then the exclusion of extras from the definition of performers. From a legal point of view, the exact same thing in respect of contract terms with the standard elements happened in the Performance Protection Amendment Bill as well. So where the bill provided for compulsory and standard terms, compulsory has been removed and it is now made standard elements. So I'm not going to go into detail here because it is exactly the same rationale. In respect of Section 3A, it speaks to standard elements. Section 8D speaking to regulations prescribing standard elements. Chair, those are the legal matters that affects both of the bills. So from my side, that is my presentation to this committee. Thank you, Chair.
Thank you very much, Advocate van der Merwe. Honorable Mulder, we are not done with our presentation. Do you want to ask a question? Because we will come back at the end of DTIC's presentation. Honorable
Thank you,
Mulder.
Chair. I will wait. Thank you, Chair.
Okay, that's great. Okay, then. Dr. Masocha.
Good morning, Chair. Good morning, honorable members. Good morning to everyone in the platform. Would like to take this moment to wish all the honorable members and all the everyone in the platform a blessed 2024. I would like to acknowledge my colleagues from the DTIC and also Advocate van der Merwe and the team in the parliamentary staff. My part will be restricted to the areas that Advocate indicated in her slides in terms of the policy issues. I'm going to try to flash the presentation. Just want to share to see if I can put it in presentation mode. Chair, is it visible in presentation mode?
Yes, it is. Thank you very much. It is.
Thank you. So I won't repeat some of the things that Advocate indicated in terms of the background, but then in terms of the outline, these are the provisions that I will be speaking to where the changes were made. And what will be clearer is the fact that we have more slides that are looking at the issues of the royalty remuneration provisions and the consequential amendments that have been affected by the changes made in the royalty provisions. So this is the outline of the provisions. Most of them are related to issues around the remuneration models, and there will be that aspect of the broadcast definition and one of the exceptions that have been amended and changes made in terms of the regulations. And this will just be most of the areas that will be addressed. Before going into the detail, just to give an outline of the recap of the processes that were undertaken since the National Assembly process when the bills were adopted in 2022. They were adopted on the 1st of September in 2022, and they were referred to the National Council of Provinces, and the initial briefing took place on the 25th of October of 2022 in the Select Committee. Following that briefing, there were provincial briefings that took place with the legislatures of the provinces. The initial briefings took place between the 1st and the 4th of November of 2022, and there were others that followed in the next year, because not all of them could be done before the end of the year. Then the committee advertised the bills for public comment between December and January, and there were public hearings that were held in the Select Committee between February and March of 2023. Following that were extensive public hearings in provinces, in all 9 provinces. And there were more than 40 held across the country. And then there was a session of the public submissions where we had to respond in Parliament as a department, and also the Parliamentary Legal Office participated in that process on the 18th of April 2023. They were then followed by the negotiating mandates by provinces in May of 2023. Following that, there were responses that we had to then provide to the mandates. And that process took place between May and June, where there were responses and proposed amendments that were looked at based on the public submissions and the discussions also at the committee. And then the E-list was prepared in terms of the amendments that will be that are now in the new amended bills. The final mandates were submitted by the provinces in September of 2023. The meeting of the 5th of September adopted the report. 7 provinces voted in favor of the bills. 1 province abstained, and then 1 voted not in favor of the bill, of the 2 bills. Then the NCOP adopted the bills on the 26th of September 2023, and they were then referred to the National Assembly. And then this new process where now we are looking at those proposed amendments. This is just a diagram of the voting, because I've already mentioned how it was dealt with. It's just to indicate how the provinces voted, and just to summarize that. I'll go into the Copyright Amendment Bill. I'll start with the definition of broadcast. So in terms of the amendments that were proposed, there were provinces that looked at the issue of broadcast. And in the public hearings and the public debates, and where we responded, there were experts who also raised concerns with issues around the definition of broadcast, which is currently in both, which was in both bills at the time before it was then removed from both bills. So part of the concerns were that the definition excludes other forms of broadcast transmissions or forms of transmission. For example, the Northwest indicated that it was not clear if the definition is meant to expand broadcast to encrypted signals provided on wired platforms, such as mobile platforms or online platforms. So they had a challenge in terms of the scope of what these, what the technicalities around what we're referring to in terms of the scope of broadcasting or broadcast. And there was a wider debate around the inclusion of wire in terms of the treaty commitments to say should wire be part of this definition. And the wire discussion was very wide, because at some point in the parliamentary process, there was consultation that was made with other role players outside in the industry to assist with clarification of implications of removing wire. So there were those complications. And in fact, one of the provinces was also raising the issue around the terminologies as indicated. Say, for example, what does public reception mean? Are we referring to that? And currently there are global considerations around the broadcasting sector. In the WIPO, in the World Intellectual Property Organization, there is a treaty that is currently underway or under discussion on broadcasting. And the Department of Communication and Digital Technologies is also looking at the white paper on broadcasting. So we realize that we also, there are policy implications and work that is being undertaken on this area. So with all the complications and the various discussions, there was a consideration, and also taking into account the provinces that raised the concern about it, either from a technical legal terminology point of view, or provinces that were clear, for instance, Gauteng, in terms of the fact that maybe consideration should be to retain the current definition that is in the Copyright Act. Consideration was made to recommend that the current definition that is in the Act be retained. So in terms of the implications, it was then recommended that this definition that is in the Act of 1978 be retained, and the other changes that were made in the parliamentary process and the subsequent changes based on public participation be put on hold while other processes, for example, the policy debates in other platforms are taking place, and also where there could be sufficient time to look at the other implications as per the debates and the guidance that has been received from various public participation consideration. So on that basis, this was recommended. The committee adopted the recommendation. So broadcast has then been removed from the Copyright Amendment Bill. based on the rationale indicated. The next set of slides are going to look at the remuneration models. So focusing on issues of royalties and consideration of other remuneration models. Overall, there was comments that came through from the provinces and from the public around the model of royalty payments and the remuneration model in the bills, to say, in the copyright amendment bill per se, to say that it was approaching the remuneration from a one-size-fits-all across all sectors in the copyright-based industries in the bill, to say that not all industries use royalties as a payment model. You can have the advances, the once-off payments. There are other ways that remuneration is applied. So the concern was that by restricting this to royalties, then it makes it look like all the sectors are the same. So to clarify, it was never or not the intention of the bill to treat all industries as the same. We recognize that copyright-based industries differ and they would approach issues differently, including how they contract. And that also speaks to the remuneration-related issues. So on that basis, consideration was then taken to say that this could be approached by looking at a broader approach of accommodating other forms of remuneration apart from the royalties, taking into account that it could be a remuneration that is based on the contribution of either the performer or the author, but ensuring that it is equitable. Equitable not meaning equal, depending on the dynamics of that arrangement, that contract, and the contributions, market forces, things like that. So also currently in the bill, the royalty provisions were strengthened based on the fact that the act as it was quite outdated, and some of the provisions had to be strengthened. And the difference now is that where we used to have the share of royalties, we now also include equitable remuneration to accommodate the concern of the one-size-fits-all on the various forms of payment methods or remuneration models across the industries. So you will, honorable members will notice that from the next slide, following the next slides, the approach will be on different provisions. There will be this emphasis on equitable remuneration. I am going to move faster on the different slides because they will be similar. The rationale will be the same. But where there is royalties, we have also included equitable remuneration. On this particular slide is on the long title, because on the long title, it was introducing the various forms of royalties. And where we had royalties on the long title, now we also included equitable remuneration, looking at the share of royalties in the long title. The same applies to the royalty-specific provisions. Clause 5, Section 6A, looking at the musical or literary works. Same principle of addressing the concern from the provinces about the one-size-fits-all remuneration model. Gauteng was very clear around that in terms of the example they used of a particular industry. It was raised also by the other provinces, I think also Northern Cape around this, so and other stakeholders. So this is the same principle. Equitable remuneration has been included in Section 6A. Similar to Section 7A, which focuses on visual artistic works, taking into account the same principle to ensure that it's not one size fits all, but then we accommodate other forms of remuneration. And likewise, in Section 8A, that deals with audiovisual works, the same principle around the issue around ensuring that there is that consideration for other forms of remuneration. This one is a different amendment. it's focusing on the specific exceptions from copyright protection applicable to all works. Is Section 12B, subsection 6. It addresses the issue of parallel importation. Here, the province that raised the concern was concerned with the wording, the technical legal wording, to say that assignment of ownership it shouldn't be used the way it was. Instead, they preferred that the wording of transfer of ownership be used as per the article in the WIPO Copyright Treaty. And in their view, the way that it has been drafted, it was an error. So we looked at the wording in this regard to say, when you look at assignment where a transfer of ownership is transferred of copyright, the wording of ownership, although they proposed transfer to align with the word, the language we use in the Act, the consideration was made to maybe remove the word of ownership because assignment still covers that. So the ownership was deleted. And the wording there on the slide is just to indicate what it means when that is taken out. So this exception deals with the parallel import or the first sale doctrine, which means that once the goods have been put on the market with the consent of the right holder, the further circulation cannot be controlled. It refers to the original sold by the right holder with his consent in another market and then imported through a parallel channel. So it was meant to address issues of where there are issues of, let's say, books and which are expensive and ensuring that there's more competition and the market is widened to deal with such issues. And it's a technical legal correction of a wording in terms of the more appropriate wording around this. So the word of ownership has been recommended for deletion, and the committee has supported that amendment, and it has been changed in the current bill. And the provincial input was then taken into consideration. The next slide talks to the commissioned works. And here it's more around the remuneration issue of the royalties. So I will not go into its detail, but it talks to the commission works, how the provision applies to certain industries, for example, the photography, the painting, drawings, and also the role of the tribunal. And that's where the royalty payment issue comes in, where certain conditions are not met. Say, for example, where the work is used for a purpose other than that for which it was commissioned, where the tribunal can order that the person who commissioned the work to make a payment. So initially it was payment of royalties. Now it's equitable remuneration or royalties. It's just to add that consequential amendment around the remuneration. And the same applies to the next one on the licenses in respect of orphan works. So this is section 22A. And it provides, so these are the licenses that provides for license for orphan works, which means a work in which copyright subsists. The owner of that right cannot be identified. If they are identified, they cannot be located. So that whole provision provides a process of how orphan works can be then accounted for, retrieved, and is a similar amendment in terms of equitable remuneration, because in this provision, there are amendments that talks to royalties on the payment arrangements. So where there are royalties, equitable remuneration has been added. On the collecting societies, section 22B, a full chapter that was inserted in the bill dealing with the governance of collecting society, their membership accreditation, commencement, administration of rights, cancellation, and so on. What they stand for and how the bill intends to strengthen their governance. it also has a lot of emphasis on royalties and payments, because collecting societies, that's their role, is their mandate to ensure facilitation, coordination, distribution of royalties, payments of royalties, collection, and so on. So in this particular chapter, there are 21 instances where we had royalties, equitable remuneration has been incorporated. Clause 33, Section 29, dealing with the functions of the tribunal, copyright tribunal, also has a subsection that has emphasis on remuneration on royalties, where equitable remuneration has been considered, which is Section 29H, subsection 2E. So there, where there was royalties, then equitable remuneration is like a subsequent, consequential amendment. The next slide is on Clause 35, Section 39 on the regulations. So I'll speak to the issues of, it includes issues of equitable remuneration in the blue color, where the consequential amendment is made. I won't speak to those. The emphasis here will be on the royalty rates. There were provinces that talked to the fact that there shouldn't be emphasis on regulating royalty rates, that royalty rates must not be prescribed. The minister must not be given so much powers to prescribe details around the royalty rates, and that it may not be competitive. Some also spoke to issues of investment around that. And so after considering that, there was a recommendation that the sub-clause or sub-provision that dealt with the prescription of royalty rates be removed from the bill. So it has been removed, consideration being that this should be left to the market forces, to contractual arrangements between parties in their agreements, and that it should be dictated by market conditions rather than being prescribed by a minister. So it has been addressed. The one that has been made specific is around the resale royalty rights. The resale royalty rights is a new form of royalty in the visual artistic works. It's about the value of artistic works that appreciate over time. Certain art forms appreciate over time. Certain sculptures, certain paintings, over time they appreciate in value. So because of that, this royalty rate has been introduced in the Copyright Amendment Bill. It is a Berne Convention type of royalty, and in the bill, the minister and the minister responsible for arts is empowered to set the royalty rate. And in the Berne Convention, countries are given that leeway to make such arrangements. And there are examples of countries that have already have this kind of royalty, and also stakeholders. Some of the stakeholders, one of them recommended that maybe this should be limited to this form of royalty. So a serious consideration was taken to look into this, and hence the only royalty rate that is considered to be prescribed is the one that deals with the resale royalty rights. And the next slide talks to the Schedule 2 of the licenses. Is the same principle around the royalties and equitable remuneration. So where there was royalties on these licenses, where emphasis was made on royalties, now we are talking about equitable remuneration. So this was just to give an example of where those are in the particular provision. And honorable members have the slide, so I won't be going through it in detail. The next bill is the Performance Protection Amendment Bill. We've included the purpose of this bill. I won't go into them. Just as a recap of what this bill addresses, and to talk to the amendment that is in the Performance Protection Amendment Bill. The definition of broadcast was in both bills. So because of they are similar, and the debates around them were approached the same way. So meaning that explanation provided about the provinces that raise concerns with the application of the definition, and the other discussions in the select committee around it and guidance from other experts has led to its consideration for it to be amended. Also, the fact that there are policy considerations currently internationally and locally, meaning that there might be changes that are required further on in the later stage. So that the recommendation is to retain this provision, the current act as it is, the definition in the act, without looking at the bill. So it has been removed from the bill. The next one is around the definition of performer. On this one, there were comments made about performer should be widened. I think Northwest suggested that there should be more types of performers considered. Gauteng was very specific about the extras, and their comment was also linked to other stakeholders who raised the same issue around the use of extras. So in a normal production, in either film or television production, there will be participants or those who assist in the production, but they don't have a role that is ongoing, and they will normally maybe have one action. They don't say much or nothing at all. And those individuals are called extras. They are there to support the production, but they're not the main performers, and they're not listed as such, but they're there to support. So there was a concern that there is confusion about the extras, that they could be perceived as performers. So there was a recommendation that it should be made explicit that extras are not part of performers. Clarity should be provided that, in our view, even in terms of the treaties, performers, extras are not even the treaties don't exclude them. Meaning, in the definition in the WIPO treaties that deals with performers, there is no emphasis on extras where they're excluded, to say they're not included. However, because of the concern that was raised and the fact that it was one of those comments that were repeated from various processes, including in the process in the Select Committee and the NCOP, a consideration was made to consider to bring more clarity and to highlight that the extras are not included. So it will read as part of the definition will also include, but does not include extras, ancillary participants, or incidental participants. So the definition will have a phrase or terms like that to ensure that these extras are not part of performers, and it's made very clear. So that explains the issue around the extras and why they were taken into consideration. Even if they were not included, it would not have affected the definition, but to consider the concern from the industry and the provinces that raised the issue around that, that consideration was then provided to ensure more clarity and certainty. Chair, that was the last slide. Thank you very much.
Thank you very much, Dr. Masocha. Committee members, I will now take hands. The first person is Honorable Mulder. Let me take other hands. Honorable McPherson. I don't see any further hands. Honorable Mulder.
Thank you, Honourable Chair. Thank you for the presentations from Advocate van der Merwe and from the DTI. I wish to highlight 5 issues came out of the out of the presentations, and the reason why I'm doing it is not to be trying to set up new obstacles, but because I'm concerned, we should consider if you look at the history, December last year, 2023, it was exactly 10 years ago that the Intellectual Property Amendment Act was published as an Act of Parliament. And this copyright amendment has been in process for 6.5 years now. And in both these bills and acts at the end of the day will have great consequences once they're through and come into action. So we should be very responsible. My questions, and I've got 5 issues that I wish to be highlighted to Advocate van der Merwe. And I must first say that Advocate van der Merwe, if I can put it in this way, I'm sure that the committee bow to your superior knowledge about this topic. But there are some real concerns with respect that I wish to raise. The first one being that we shouldn't have a situation where the committee has been steered, a legislative committee like this DTI committee, portfolio committee. The committee shouldn't be directed or steered in a direction of a predetermined outcome. I understand that, like I mentioned earlier, that you've got more knowledge on the topic that the members of the committee's got, but it seems to me that we are steered, that the committee has been steered in the direction of a predetermined outcome. And I know, if I remember correctly, that this concern has been raised in the National Council of Provinces as well. You could correct me if I'm wrong. So the first concern then would be about okay, I've raised that now about the terminology of technical. You mentioned in your presentation, you see that the amendments are discussed in one concept at a time. The amendments are technical in nature. They do not affect the classification, nor do they render the bills constitutionally or procedurally out of order. Now, I'm afraid I must differ. I've got a different opinion on this. These amendments are not technical. They are definitely, they will have constitutional implications. So I disagree on that. And then the second one is Advocate van der Merwe also mentioned explicitly that she's of opinion that there's no need for public hearings. Now, if I refer to the terminology that's been used, standard elements, it's a substantial amendment, and the public wouldn't know what the implications are. What does it mean? If you do a search in LexisNexis, you wouldn't find the terminology standard elements there. And I seriously want to ask the committee that we should consider public participation. We do not want to go in a situation where this 10 years and 6.5 years has been repeated or extended. My third issue is about the definition of performer and extras, where royalties and equitable remuneration is involved. I would like Advocate van der Merwe just to explain her view and explain exactly what it means, how she understands it, so that we can also understand the performer, the definition of performer and extras, where that's been amended. And then the next question or issue that I want to raise is about the definition of broadcast. Now, I was the member who asked the question about the blind SA case, and the answer was indeed, like Advocate van der Merwe said, that it was not about the act, but about the bill. Now, it might be technical, but I wish to disagree, because the application was to include 19D in the bill. and the Constitution Court didn't want to allow for that. I think we should just clarify that. And then lastly, persons who are blind or visually impaired. I think that this alteration or possible alteration should not take that long. We should not look into the D-date of September 2024 and be under the impression that this persons who are blind or visually impaired, the definition of that could not be altered or rectified. I think it's something that could be rectified very quickly. Thank you, Chair.
Thank you, Honourable Mulder. Honourable McPherson.
Thanks, Chair. I think this has probably been one of the messiest pieces of legislation that have ever come through Parliament in 30 years because of the cack-handed way in which it has been dealt with from the beginning. And despite many of us imploring the committee and the department to actually listen to people, everyone decided to plow on because they all wanted to be able to hang something before the electorate. And I think that that is a real shame, because that's why we are still here all these years later with what is just a real big mess in front of us. And I think that we are trying to, unscramble an egg, which is quite frankly a problem for me. So is it not better then to actually just deal with those issues relating to Blind SA and the matters around that, and not the other which I agree with my honourable friend from the Freedom Front Plus, are substantive. I don't think that they are just sort of technical changes, and that we are sort of being pushed to do something because there's this, this constitutional court deadline, and we're trying to throw everything all in with that. And I just think that it's wrong. And all we are doing is we are further complicating what is already a complicated process. So I'd really ask again, because myself and one or two other people have been the only sober people in the room that have been warning about this for, at least 8 years, that please can we actually just deal with those issues that relate to the visually impaired, and all those other issues actually need to be looked at separately. So I do hope that that will be taken. Thanks.
Thank you very much, Honourable McPherson. Advocate van der Merwe. Any responses?
Yes, thank you, Chairperson, and thank you to the members for the responses. Chair, I don't think that Mr. McPherson's comments were necessarily directed at me in this respect of comments. I think it's more something for the committee to consider. But definitely on Mr. Mulder, there's a couple of things that I would like to comment on. The concern that he mentioned in the NCOP is it was raised by one province that because I've been involved in this bill since 2017, it was very difficult for them to word it, and I find it difficult myself to word it, because they were saying there's no aspersions cast, but perhaps my advice could be biased and there could be different advice to be given to the committees. So what we have done is I have taken all my advice to my chief legal advisor, who has requested a peer examination in our office. And the peer examination showed that there was full agreement with every single piece of legal advice that I provided to the select committee, as well as to the portfolio committee, because I took from my advice to the portfolio committee when advising the select committee to ensure that there is consistency in my advice. So to say that the committee may be steered in a predetermined outcome, Chair, that might be a perception, and I hope that was not a perception that I created. My presentation, and I'm sure the same goes for the department, is simply to brief the committee on what the National Council of Provinces decided in respect of amendments, why those amendments were proposed. So it is for this committee to then discuss those amendments and the rationale as we presented. I've indicated also at the outset of my presentation that this committee may consult with the select committee. So if there is any concern that the rationale is not clear for why an amendment was made, the committee may consult with select committee to ascertain that. And then this committee must take each amendment and decide whether each amendment made by the NCOP and decide whether this committee agrees with it or not. That is the limit that this committee is put to by the rules, by the assembly rules. So it's not something that I've prescribed. It's the rules that limit the committee. So if that is perhaps what is meant by predetermined, it's something that the National Assembly rules do. It says that this committee must limit itself to the amendments made by the select committee. So at best, what myself and Dr. Msotsha can do is to tell the committee what those amendments are and why they are there. Dr. Mulder also indicated that he's of the view that the amendments are technical and will have constitutional implications. I have considered the amendments in the select committee. I've advised the select committee. As I've said, my advice was also peer-reviewed in our office. My chief also looked at my advice, and the advice was found to be correct and in compliance with constitutional principles. I accept that the Constitutional Court may, on any matter that we present to a committee, come to a different conclusion. That is something that as lawyers, that's what keeps us in a job, is the fact that the court may come to a different conclusion. That's why we can have two opposing factors and both parties argue very, very convincingly for their matters. But what I can say to this committee is that my advice has been tested in our office, and I am of the view that every single amendment is something that is technical in nature. And with technical, I mean that it was either addressing a drafting concern, or it was making the intention that was already in the bill clearer. In other words, there were some concerns about how something was worded, and that was corrected. Some of the other amendments on the policy side, for instance, the deletion of broadcast, the inclusion of extra. I will leave that question, by the way, if I may, to Dr. Msotsha, because that's a policy question, not something I can respond to. But those kind of things were concerns that were raised in the portfolio committee, again raised in the select committee, and the questions in the select committee and from the provinces simply then resulted in those amendments actually then being made in the NCOP. So yeah, I said on the question of for public hearings, the term that needs to be searched for is elements of a contract, and that will be found. So what we have here is that we are simply defining elements in this clause, and that is allowed. We can, when we draft, we don't have to do all our definitions in a clause in clause 1, especially not if there's a difference in if there's no difference from a dictionary definition. So elements is the meaning that it has in any legal textbook. Elements of a contract. What we are doing is to say that it must be the standard elements for a contract between the copyright owner or person who will become copyright owner and the author. And those standards will relate to protection and rights afforded by the bill, by the act, once the bill has passed, of course. So that is why I'm saying there's no need for that to be there's no need for a definition. And also the amendment that is made is simply reverting or rather putting a different wording there to address the concerns. The meaning is exactly the same. So there is no difference, and there is no need for public participation. On public participation itself, it is always open to every committee to have public participation. That is not something I can tell the committee is something to decide for or against. What I can advise the committee is that if we look at the case law, we are only required to call for comments if there are new matters that the public has not had an opportunity to provide an input on, or if it is a material amendment. In other words, the whole concept, for instance, changes. and then it will be that will be a material implication and material amendment, and it does depend from case to case. And I have considered every single amendment in this bill, and I'm of the view that it is my advice to the committee, but it doesn't have to affect the committee's decision. My advice would be that I do not see the Truworths case or the Saba case being triggered by the amendments made in this bill. They are all simply of a nature to clarify and to correct drafting errors, things like that. So as I said, the issue of blind SA, I'm not sure that I understand the question 100%. I said that the blind SA judgment was not about the bill. It was in fact about the Copyright Act. So it did not affect the bill at all. The court did consider Section 19D, which deals with disabilities. The court could not use 19D as it is in the bill because it is much broader than the facts that were before the court. So the court cannot, if the facts before them deals with the blind and visually impaired, also make a finding that will affect persons with a hearing disability, with a physical disability, a movement disability, a learning disability. They can't make a judgment that extends that far. The works that were before the court was only literary works. And one of the examples that we actually got was if you have notes, for instance, that someone is playing, you know, like on a violin or a piano, you've got a sheet, a music sheet. Is that a literary work? If the song tells a little story, is it a music work? Is it something different? So it's necessary that all works are covered. And that is all that Section 19D does. And that is why it differs from the court judgment. The court was limited to the facts before it. This committee is not. This committee is required by the Constitution to provide equal protection for all persons with disabilities. So that is why 19D is in the bill. The court did not find anything unconstitutional about Section 19D. The court did not put any criticism about Section 19D. The court simply indicated that it cannot use it because it was too broad. In respect of the deadline, the September 24 deadline, I'm keeping a very close eye on that deadline. If anything, if this committee for any reason decides that it is not going to accept certain of the amendments of the NCRP, for instance, I will be briefing this committee on a committee bill very, very soon thereafter. I will ask for a meeting very, very quickly because we need to then do a committee bill on blind SA. So I think that this committee, depending on the decision on the NCRP amendments, should be able to still make the deadline of September 2024. So I agree that we can make it. The draft's already there. Thank you, Chair. If I may then ask to hand over to Dr. Masocha on the question related to the definition of performer, extras, royalties, and equitable remuneration. Thank you, Chair.
Thank you very much, Dr. Masocha.
Thank you, Honorable Chair. Thank you, Honorable Mulder and Honorable McPherson. I will talk to the two areas that advocate has indicated. In terms of the performer and the extra, and I hope I understood the input or the comment by Honorable Mulder to say, what does it say? What does the definition in the bill currently say versus the extras? I had it more in terms of what is the provision saying. So I'm going to then try to respond from an angle of highlighting what the definition of performer is in the bill, and then indicating the additional that was done. So unfortunately, I did not have it on the slide in terms of this as a provision, but if allowed, I will just read through it slowly just to indicate what the performer is, and then indicate the additional that has been added to address the exclusion of the extras. So as per the finalized bills in the Select Committee and the NCOP, the definition as it stands now is that a performer means an actor, a singer, musician, dancer, or other person who acts, sings, delivers, declaims, plays in, or otherwise performs literary works, musical works, artistic works, dramatic works. And in terms of the current bill, there was an addition of all traditional works as contemplated in the Copyright Act. And then the addition for the extras reads as, but does not include extras, auxiliary participant, or incidental participants. So in the definition that was in the bill, the exclusion of extras was added by adding the wording that says, but does not include extras, auxiliary participants, or incidental participants. So the definition is in the Performers Protection Amendment Bill. There is amendments that were made, some in the initial parliamentary process, taking into account traditional works as contemplated in the Act, and also now excluding the extras. And the extras being those persons who participate in productions in films and your television productions, but they are not the main, they don't form part of the main performances in terms of the main performers who are liable for your royalties or who are more active and regular. So they're not your regular participants in a particular production. So the main item or emphasis being that there is that exclusion that says, but does not include extra auxiliary participants or incidental participants. In terms of the equitable remuneration, the term equitable remuneration, the definition, it is the language that is used in the treaty language. In the Beijing Treaty, there is equitable remuneration. I think also in the WIPO phonograms treaty, there is that wording. So the equitable remuneration is also globally used in terms of remunerations, especially mainly for performers, but it can also apply in terms of ensuring that the contribution by the author and the performer is addressed in an equitable manner. I've heard some arguing that equitable means equal, and that is not what it means. It means for the performance, for what is due to a performer, what is due to an author, the payments must be equitable, they must be fair, there must be that the partiality around that. So given that there was the concern about the remuneration model being restricted to royalties that take a particular form, concern was that there should be allowance to other forms of remuneration. So the best wording that was even recommended by those who are in the industries themselves was around the wording equitable remuneration. I hope that clarifies it. Thanks, Chair.
Thank you very much, Dr. Masocha. The committee has now been briefed. Honorable Mbuyane, before I close. Honorable Mbuyane.
Okay, no, thank you very much, Chairperson. Thanks for the opportunity, and also welcome both presentation from the advocate and also from the doctor. I just wanted to elaborate on a few issues that there's no changes in its substance and also the content in terms of the bill and also the process, because some are alleging that the process is not complicated. The process is not complicated at all, and also the matter was clearly clarified on the process. Chair, the essence of the bill that has not been changed in the absence of any substance argument to the contrary. There's no basis to open the process again for public party consultation. And also the fact of the matter is that the committee has had extensive public participation for more than 5 years now. This is just, I wanted to raise those issues, Chair, before you can conclude on the matter. Thank you very much.
Thank you very much, Honorable Mbuyane. I just wanted to check with the committee secretariat on our way forward do we take the request for more public participation as a proposal and then have it seconded, and then the counter proposal made by Honorable Mbuyane, is that required in terms of committee procedure?
Chairperson, if the committee so decide that they wish to do so, Chair, it would be required that it's seconded, and then the committee make a decision regarding that. Chair, as Advocate van der Merwe has indicated, the rules, NA Rule 311, limits the extent to what the committee can do, and we will be confined to that, Chair. And as indicated, that the committee has received a presentation from the DTIC as well as Advocate van der Merwe in terms of from a legal perspective and a policy perspective, and members then have to apply their minds and then consider each amendment in accordance with that, Chair. So with regard to your first question, Chair, it will be just, we can deal with it in that manner. If the committee feels that there should be public, further public participation, the committee can take that decision now, Chair. And then at the next meeting, we will then look at the formally considered the NCOP amendments, and the committee can then move forward with that, Chair. Thanks.
Okay, but doesn't that put us outside, Advocate van der Merwe, what it is that we can do in terms of the NCOP amendments?
Chairperson, if the committee decides to have public hearings, it can only be on the amendments from the NCOP. So it will have to be limited to those clauses that were presented today, and those clauses, only the amendments in those clauses. So if there's public hearings, that is what it will have to be limited to. It cannot go broader. And then if there are inputs from the public that go broader, it will have to be ignored. We cannot, the rules do not allow the committee to go broader than the NCOP amendments at all. Thank you.
Thank you. So I think then for committee processes, let us take Honorable Mulder's proposal and see if there's a seconder for his proposal. And we have had a counter proposal. Yes, who's speaking?
Mr. McPherson.
Okay, Honorable McPherson has seconded. And then we have a counter proposal. Can we have a seconder for the counter proposal from Honorable Mbuyane?
Mr. Monakedi, Chair.
Honorable Monakedi.
Chair, thank you. I am raising my hand to second the way forward and proposal as motivated by Honorable Mbuyane. Thank you.
Thank you very much. We'll now put the first proposal to the vote, the proposal by Honorable Mulder, bearing in mind the briefing that we have from our legal advisor. Secretary, I hand over to you to manage this process.
I will call the name with regard to the first proposal that we shall have public hearings on the matter. Mr. Malamatia. Mr. Malamatia. I'll go to Dr. Ntwane.
No, Chair.
Mr. Mbuyane.
Voting against, Chair.
Ms. Muwatse.
I'm voting against, Chair.
Mr. Monakedi. Mr. Monakedi.
I'm sorry, I did not unmute. No, I was saying I'm voting against what is on the table at the moment. Thank you.
Chair, we have Mr. Malamatia, Chair.
Yeah, thanks, Chair. I'm battling with your network. Against, I'm voting against.
Mr. Bergman. Mr. Bergman. Mr. Three.
In support, thank you.
Mr. McPherson.
In support.
Mr. Mulder,
In support of public participation. Thank you, Chair.
Ms. Floniana, Chair, and yourself, Chair.
I vote against.
Chair, we didn't hear from I think Mr. Bergman is off the platform, and Ms. Floniana. We have then 6 against public hearings and 3 in support of public hearings. Shall we put the second question before the members, Chair?
Yes, please proceed.
Mr. Malamatia for not in favor of having public hearings. I will go to Dr. Ntwane. I'll proceed with Mr. Mbiani, Chair.
Chair, maybe to clarify, because I think members, they don't clearly understand where are we now. We're in a second proposal that say
Yes. The proposal made by the ANC, yes, Chair.
Yeah, that we don't need public participation because we did public participation for the past 5 years. Yes, I agree.
Okay, thank you, Honorable Mbiani. Just your vote.
Yes, Chair.
Ms. Muatse?
Yes, Chair.
Mr. Monakedi?
Chair, I am voting for the motion as proposed by Mr. Mbuani.
Mr. Bergman is not on the platform anymore. Mr. Three?
Not in support. Thank you, Chair.
Mr. McPherson?
Not in support.
Mr. Mulder?
Not in support, Chair.
Ms. Floniana is not on the platform. I'll just want to go to Mr. Malamatia and Dr. Ntwane, Chair.
In support, Chair.
Malamatia, yes.
Yes, and your Chair yourself?
Yes.
Chair, both questions were put before the committee. The committee is in agreement that there will be no further public hearings on the matter, Chair, as agreed to in the committee. So the second question was agreed to, Chair. Thanks.
Thank you. Okay, can you just, Committee Secretary, just brief the committee on the way forward?
Chair, based on the fact that we've received the input from Advocate van der Merwe and Dr. Socha, members will probably take the matters to the particular caucuses for further discussion, Chair. At our next meeting on the 14th, as in terms of the rules, we will consider these proposed amendments by the NCLP, whether the committee is in support of it or not, Chair. We will also, in the meantime, prepare a draft report, Chair, if the decision is taken on Wednesday, which will be distributed to members so that they can have it before we meet on Wednesday, if that's in order, Chair.
Thank you very much. By when will the members receive the report?
Hopefully, we'll try to send it before the caucuses, Chair, so they can have it to discuss it within the caucuses.
Okay.
We were making the assumption that it will go a particular way, Chair, and members can then express their views on that.
Thank you very much. Thank you very much, members, for attending this first meeting of our Trade, Industry and Competition Portfolio Committee. We've dealt with our business for today, and thank you for your attendance. We'll see each other again on the 14th. Thank you very much.
Chair, just to remind members that our meeting on the 14th will be in person in room M46 in Mark's building on Wednesday.
See you in person then. Thank you.
Thank you, Chair.
Thank you, Chair.
Thank you.
Thank you, Chair. Bye,
Thank you,
colleagues.
Chair.
Recording
Long
stopped.
live the chair, long live the chair.